Well, I hope you guys have a great week. Happy Monday. My name is Bob Bianchi. I'm the host today for the Law&Crime Report. As you know, our network covers things gavel to gavel, all interesting stories that we have on for you today, especially some little twistiness that's going on, if they could get any more twisty with regard to Lori Vallow Daybell. There are now new released audios back from October of 2008. Basically her indicating that she believes that through scriptures that she is allowed in certain instances to commit murder. You may know there's dead people all throughout this case and suspicious circumstances that are going on. We have some great experts that are going to break down, that know this case inside and out, and the relevance of what it is that we're finding, because there's one individual, Joseph Ryan, who was one of her ex-husbands, that being Daybell's ex-husband, and her sister is imploring the Arizona Police Department to reopen a death investigation. The ME medical examiner had called it a death of natural causes, and she does not believe, nor do many other, that it was natural causes. Let's listen to a little bit of what we learned from this October 2018 tape that has just been newly released.
After we were divorced, he told everybody that I was this lying, crazy Mormon, and got up in court and said all these horrible things about me, and turned it around to where the judges believed him instead of me. And he was constantly trying to get custody of my 3-year-old daughter, and just to rub it in my face. And I went through a lot of years of this kind of hard stuff, and I was going to murder him. I was going to kill him, like the scriptures say, like Nephi killed him, just to stop the pain and to stop him coming after me and to stop him coming after my children. And I just felt I couldn't take it anymore. And I would go through the scriptures and find all the things, like, if he comes against you once, if he comes against you twice, if he comes against you 3 times, then you can kill him. It says it in the scriptures in the book of Mormon. I was like, there it is. There's my answer. I don't want to do anything that's wrong. I did not have a murderous heart. I just wanted to stop the bleeding.
Well, there's the defendant, Lori Daybell, basically saying she believed in a cavalier fashion that she could murder. And that she could murder based upon what she believed were the religious tenets of her faith with regard to scriptures. Let's listen to a little bit more of this fascinating piece of evidence. And I'm going to ask our folks there, our friends, our fans here at the Law and Crime Network, get into that Facebook and let us know your thoughts about what you're thinking. And I love going in there and being able to answer some questions if you have any. Let's take a listen to a little bit more of the clip.
And so someone wise was speaking to me and said, you need to go to the temple. So I went and met my bishop, and I was like, I'm either going to turn my life to the temple or I'm going to commit murder. So do you want to give me a temple recommend? And I was perfectly honest, because at that point I had nothing to lose. You get to the bottom rung and I had nothing to lose. And he gave me my temple recommend. And I started going to the temple every week by myself. Not with my current husband, just by myself, to the temple, to the Mesa Temple, which I love. We moved here from Texas to get away from my ex-husband that was doing all this, but he moved here like 5 miles away from us, just to continue to torture me. That was his whole entire job. And Satan had been torturing me since I was a little kid, so I've had that my whole life.
Egats. Okay, we got Law and Crime royalty with us here today, because no one knows any one of these cases here at the Law and Crime Network better than our executive trial producer, Cathy Russon, and then the great Julie Rendelman, former district attorney and homicide prosecutor out of New York. She does criminal defense now, has her own firm, and she does everything involving anything to do with mayhem. Ladies, welcome to the show.
Thank you for having us.
Cathy, Cathy, got to go to you first. Only you know the twistiness of this case better than anyone else. Tell us a little bit about the case. Tell us tell us about what you think that this new piece of evidence means with regard to whether or not the police will reopen an investigation with respect to Joseph Ryan. Arizona authorities saying they don't want to do it based on a medical report that indicated that he died of natural causes. We talk about this a lot. Sometimes medical examiners lock themselves in, not necessarily with all the information, refuse to change it. Cathy, take it away in any which way, shape, or form you'd like to take it.
Okay, so to put this in context, Joseph Ryan was Tylee Ryan's father. They divorced in 2004 when Tylee was just 3 years old, and they lived in Texas. And so Lori eventually moves to Arizona, where she meets Charles Vallow, who was husband number 4. From 2004 till Joseph Ryan's death in 2018, it was a contentious custody dispute. That many years. I have read all 1,800 pages of their court documents on the child custody dispute, and it's nasty. And Lori accuses Joseph Ryan of raping her children. And he took lie detector tests. He was interviewed by psychologists. It was determined by the courts that this just didn't happen. He didn't have that in him. But Lori kept that up and kept Tylee from him. And he fought and he fought and he fought. He finally moved to Arizona to be closer to Tylee. He left all of his family and everybody he knew in Texas because he wanted to be closer to Tylee. And Lori still did everything in her power to keep them apart. But a judge made her allow him to see Tylee at times. So in April of 2018, now this is 6 months before Lori meets Chad, Joseph Ryan is found dead in his apartment. And the medical examiner determines he's been dead about a week and that he had a heart attack. And at that time, nobody knows anything. Lori hasn't met Chad yet. Nobody else is dead. And that's how it's ruled and it's over. Well, this recording was 6 months later, and it was 1 week before she met Chad Daybell. She's at Melanie Gibbs' house, which we know Melanie is her best friend, and Melanie testified at Chad Daybell's preliminary hearing. And she's talking about how when she's going through this battle with Joseph Ryan, she wanted to kill him. She wanted to murder him. She just wanted the bleeding to stop. And she kept looking in the scriptures for justification on murder. And she found it, in her words, that if someone did you wrong 3 different times, that you could kill them, which of course is not true. But she's telling the group this. This was just an informal group gathering at Melanie Gibbs' house. She's telling her story about how religion came into her life. And so from that, she started going to the Mormon temple so she wouldn't commit murder. And then a week later, she meets Chad Daybell, and then, we kind of know the story going from there.
Yeah, Julie, I mean, you don't have to search Google necessarily in order to be doing research on how to murder somebody. It may be a little twisty, but essentially what she's doing is saying that she was looking for specific ways based on the tenets of her religious faith, at least as she saw it, in order to be able to justify committing murder. What are your thoughts about that and the admissibility of this evidence at trial? By the way, we're not even at a trial. What are your thoughts about the idea, having been a former homicide prosecutor, that this should be a reopened investigation?
Well, first, I'm mad at you for letting me go after Cathy Russon, because she knows more about this than any human I know that exists in this world. But from the little I know, I can say that the biggest issue, I think you're right, is whether or not this audio is going to be admissible, not potentially at this case, and if there is eventually a homicide case. By the way, I'm not even talking about the husband who died, but whether or not it would be admissible in regards to the children's death, because some of the other aspects of the audio talk about the reason she does certain things, the reason she moved to Hawaii, the reason that she ended up, believing in certain things. And so those aspects may be relevant in terms of a jury determining what her intent was in regards to what occurred in this case. Obviously, it sounds like a bad act. It might not be admissible, but it would be interesting to see the prosecutor find some avenue of getting this in.
Yeah, and let me just expound upon that a little bit, Julie. I mean, where is the inquisitiveness? We have a number of people that die under strange circumstances. She's charged right now. I mean, sometimes you've got to use your common sense. And when you get a piece of evidence like this, you need to reevaluate. But there always seems to be that tension that once the police make the call, the medical examiner makes a call, that they just don't want to reevaluate the case. If I were the prosecutor in the case, it would be going to a different medical examiner and a different set of prosecutors and detectives to take a new look at this. Would you suggest that kind of approach?
There's no reason, based on everything we know, where, as you said, every single person seems to die around this woman, that they shouldn't take another look at every single person that has died around this woman. And that includes her ex-husband. And so, yeah, I absolutely agree with you that this is something that at least should be looked at one more time.
Okay, Cathy. So knowing the whole complexity of this case, what are your thoughts? Even though it may or may not be admissible in the case that she has right now, but it certainly could be introduced potentially as 404 evidence, or we would call other act evidence. It's different in different states. Is there, in your mind, this additional piece of evidence, if it goes before the jury in the current case she has, how does that affect the balance in your mind of evidence against her that prosecutors would present?
Well, let's keep in mind what is happening in this case. Nobody is charged with the death of those children. Lori and Chad are not charged with murder or the deaths, only concealing the body. So there's been no murder charges brought yet in any of these deaths, and there are a lot. And so we'll just remind you that her fourth husband, Charles Vallow, who she was married to while in Arizona, ends up dying by her brother, Alex Cox, shooting him, who he claimed was self-defense. She moves to Idaho right after that. Chad Daybell's still married. We know they're seeing each other at this point, and Chad's healthy wife that's in her 40s and has no complications, nothing wrong with her, dies in her sleep, and no autopsy is performed, and she's buried. So now she has two husbands dead, he has a wife dead, and now there's two kids dead. So since the children's cases had came out and the authorities realized what had happened and they were missing, now there's been investigations reopened into Chad's wife's death, Tammy. She was exhumed last December, and they have never released any information about that new autopsy being done. So we don't know her cause of death still to this day. They are still investigating Charles Vallow's death with Alex Cox shooting and killing him, saying it was self-defense, which they still were sort of investigating that when all of this other happened. So that's still open, and they are looking to charge Lori with something to do with Charles Vallow's death. The Gilbert, Arizona police have said that they are. And now Phoenix police has agreed to look again at Joseph Ryan's death. So at this moment, nobody's charged with murder in any death. So what would come in the concealing of evidence in the children's bodies trials? I don't know. I'm waiting for murder charges to come out, multiple murder charges to come out. And I feel like that is on the horizon.
Wow, excellent. Cathy Russon, a trial executive producer here at the Law and Crime Network. It was an honor to have you on, and only you could break down the twistiness of this case. Cathy is going to be leaving us for now because she's got a lot of other responsibilities at the network, but don't worry. We have another special guest that's going to be coming on the other side of the break. Stay with us. We'll be right back. Talk about another twisty case, Scott Peterson, and twisty in a legal sense. As you guys know, his death penalty conviction was vacated. The state has decided they're going to go forward with a retrial on the death penalty phase. There's also another discussion going on as to whether or not the guilt phase may actually be thrown out for some juror misconduct. So we got a lot going on here, but the development is on the penalty phase. He has waived his right to a speedy trial. So we're not going to be getting to that phase for a considerable period of time, it looks like, as of now. Let's listen to back in December 25th of 2002, an interview that Peterson gave to police.
Pretty much got all I'm going to do. Let's just go over what we already talked about so I can make some notes. See if you remember something that you don't, maybe you don't know you remember. So, today, just tell me about the morning.
Okay. I don't know what time we got up. Probably Lacey got up and went and assumed she had some cereal for breakfast. She eats right when she wakes up, otherwise she gets sick because she's pregnant. I laid around in bed longer. I got up at 8 o'clock probably or so. Showered. And, we were watching her favorite show, Martha Stewart. Watched a little bit of that.
You didn't watch the whole thing, though?
No.
You remember what part you saw? I mean, I don't know what.
Yeah. Some cooking deal. I don't know.
Okay.
Cookies of some sort. They're talking about what to do with meringue.
And I can't remember, your house, you had the converted garage area, is that your TV room like? Or
Yeah.
Is that where you were then? Okay, did you eat any breakfast?
Yeah, edible cereal.
All right, that was one of the interviews that Peterson had given to authorities at the time. We have our next guest, Jessica Ramirez, out of New Jersey from Darcy Johnson Day. She is a national legal analyst as well as a trial attorney. And perhaps one of her greatest qualifications, or at least one that I am impressed with, is that she is a graduate of Seton Hall University School of Law. I'll give you a disclaimer. I was too. Welcome to the show, Jessica.
Thank you. Thank you for having me.
Okay, so let's go to you first. I mean, this a lot of developments in the Peterson case. The family is obviously very upset about everything that's going on here with regard to the reversal of the penalty conviction and now the possibility of a reversal on a juror issue with regard to the guilt phase of the case. There have been some that have opined, and perhaps somebody that we have currently on the show, I don't know, we'll ask her a little later, with regard to the idea that the state has made a decision of California to retry this as a death penalty case. And, you know, this comes on the heels of the Golden State Killer that they did not pursue as a death penalty case. And I'm wondering, what are your thoughts about the parity of that? One life as opposed to 13 lives and a very, very sick and sadistic person, at least maybe it could be argued both are. Give me your general thoughts about any of those concepts.
I mean, you can't really equate one life as opposed to 13 lives. I think you get into a very slippery slope when you start equating one misery to another. So I think that they're not going to be looking at whether, you know, this was one life that was killed as opposed to many. I think that California and the world has taken a new turn into what is fair and more of a civil rights way of looking at the world. And so I don't think it's going to matter.
Yeah, well, you know, Julie, I took a shot at you, my friend, and we always do this in kidding because Julie is really a phenomenal lawyer. I have tremendous respect for her, even if her opinion disagrees with mine. But, going to go back to the point, Julie, I'm sorry that we do this sometimes, this dance, me and you, on a couple of cases. But if you're going to have a death penalty, if you're going to have one, and I am not a fan of the death penalty. I've tried death penalty cases as a prosecutor, but I learned more from that experience that the system is so inconsistent depending on what county you're from or what prosecutor you have, and people see things differently. And I'm just curious. It just confounds me again. It's more the Golden State Killer thing. If not that case, what other case? And he gets no death penalty. He gets life. Peterson is being retried for the death penalty. Look, if there's a moratorium on the death penalty in California, and there is one right now, what's the sense of even pursuing these things anymore? And last point, I know there's an argument that the victims' families don't want to go through it again, and we know that they don't want to go through it again in the Peterson trial as well. Thoughts, Julie?
Well, I don't know that we completely disagree. I'm clearly not a fan of the death penalty from anyone who's heard from me. I think, if we're just speaking facts, because I think that the way the death penalty is meted out is completely inconsistent, and which makes it impossible for it to be used. And I have other reasons why I'm against it. But in this specific scenario, the facts are different, if I'm just going to talk about the facts. And the difference is that in the Golden State case, the desire is for them to get him to admit to as many cases as possible, particularly those that are not falling within the statute of limitations. And so that was one of the reasons they gave why they took it off the table. The other reason they gave was about the pandemic. Now, the interesting thing is that the difference is now they're both, Scott Peterson, if he's retried for that specific aspect, we're in the midst of a pandemic. That might be the reason that they delayed it, but it does seem a little inconsistent if we're comparing those two specific issues.
So Julie, maybe on this date of November 9th, 2020, we can say we're really not that far apart on these issues. Is that fair?
Just today. I'm allowing it.
Subject to change tomorrow. Guys, listen, the lawyer for Scott Peterson, who by all accounts, as far as lawyering is concerned, is doing a very good job. And he believed that the reversal of the penalty conviction, as well as his attempts now to get out of the guilt phase of that, are completely justifiable. Let's take a listen.
I have argued that, in fact, the guilt phase should also be reversed. Now, the state disagrees with me. I understand why. And let me state that there's been a lot of water under this bridge. I recognize that in many cases, this court has held that improper discharge of jurors under Witherspoon requires reversal only of the penalty phase. So it seems to me that the burden fairly falls upon me to persuade this court of 2 points. First, I need to persuade this court that this is an open question. It's not foreclosed by precedent. And second, it seems to me that the burden is fairly placed on me to show the court that in addition to not being foreclosed by precedent, that this argument is correct on the merits. Let me see if I can do those relatively quickly now. In terms of precedent, I don't think there's going to be any disagreement that Witherspoon doesn't resolve this under the Eighth Amendment. Witherspoon was a Sixth Amendment case. Indeed, it couldn't have been an Eighth Amendment case because it was decided in 1968, 4 years before the court began its march toward employing the Eighth Amendment in assessing capital jurisprudence processes in Furman. So Witherspoon isn't the Eighth Amendment barrier. The state, to its credit, recognizes that and says, well, this court has held that proper death qualification doesn't violate the Eighth Amendment. And the state is right. In cases from Hovey on down, and the U.S. Supreme Court has also reached this decision in Lockhart. But this is not proper death qualification, and that's important for 2 reasons. One, proper death qualification, and Hovey has an interesting opinion on this, and they use interesting language. Proper death qualification at least leaves the jury balanced. I think Hovey called it a neutral jury. Because after all, you may be taking off people that oppose the death penalty and won't consider death as an option. But you're also taking off the jury people who are in favor of the death penalty and won't consider life as an option. So the jury remains balanced. What happened here was a systematic exclusion of people who were opposed to the death penalty but would consider death as an option. Now, you weren't doing improper life qualifying under Morgan. The trial court didn't discharge people who were in favor of the death penalty but would consider life. That would at least leave a balanced jury of people who were indifferent, as I think the language, or neutral on the death penalty. So what we have here is something very different. We don't have a disqualification scheme that results in a balanced jury. We have a disqualification scheme that results in an imbalanced jury.
All right, Ms. Rendelman, let me ask you, can you break that down for us in basic terms, and especially as it relates to the idea that the court reversed the penalty conviction because they agreed with the defense lawyer's argument there, but explain to the audience why that does not necessarily transfer over to the guilt phase.
I'll be honest, I don't really know why it doesn't. Obviously, Cliff Gardner talks about the case law, which basically the precedent was that, you know, if there's impropriety with regards to the jury, that it impacts the sentencing phase, the death penalty phase, but it doesn't impact the guilt phase. What he's saying is that the facts in that specific case are different in terms of the fact that in this case, they removed only those individuals that were anti-death but we're still willing to be open to the idea of giving death, and kept those individuals that supported death. So there is a strong argument to be made. I have to admit that those individuals who are kept on the jury that remain are those that are more inclined to not only accept death, but arguably accept guilt. Because if you're so open to death, there's an argument to be made that you may be more swayed towards guilt. I think he makes an excellent comparison between the two of them. And I think, look, again, I don't know that he's going to win that part, but he certainly is the person that would have the ability to do so.
All right, Julie, excellent explanation. As always, they should actually be listening to you when you made that argument when they're referring to the guilt phase. What do you think there? Our law and crime aficionados on Facebook, let us know. Jessica, you get the first question coming back. It's going to be dealing with COVID-19 and how it's affecting our trial system. Stay with us. We'll be right back. All right. Jessica had to leave us, so I will be with Julie Rendelman, the great, for the rest of the show. Listen, COVID-19 outbreak, and we have the Stalls of Letecia Stauch trial for at least a month. Now, you may remember this case. We've covered it, at least in brief, on a couple of occasions. So she's a 37-year-old. The defense has requested that she be able to see a defense psychiatric expert with regard to whether she's competent. That meeting was not allowed to occur. Now, a previous psychologist had indicated that she was competent. The defense wants to take another crack at that. She is accused of murdering her 11-year-old stepchild in the state of Colorado. And so we're just going to have to wait a little bit about that. Julie, this is the life we're living in COVID-19. Both you and I are practicing practitioners. Each state is trying desperately to wrap their arms, especially in the criminal law section, because people have certain constitutional rights to a right to a speedy trial. And these cases just can't move to trial. Here in our state of New Jersey, a couple of cases have actually gone to trial. They've just started that process up and running, but there's no doubt about the fact it's created tremendous backlogs, and this is just yet another one of them. How do you think the courts sort this all out down the road? And are the defendants going to have any possible decent claims of speedy trial violations?
Great questions. They started a case actually in the Bronx. They were on trial and had to literally shut down the whole courthouse because several individuals tested positive for COVID. So they had to stop the trial. I think that there are going to be. So here's the thing. I think two things are happening. One is we're noticing that less individuals are getting bail. Besides the fact, specifically in New York, that the bail laws have changed. I think the judges are more open to releasing individuals based on the pandemic. I think the second thing that you're going to find is that the district attorneys are resolving cases that they would normally probably be a little more strict on. They're resolving them a little more quickly. I think at the end of the day, when trials really start, the first trials that should begin are those of which the defendants are incarcerated, because those are the individuals that have a liberty issue at stake immediately. And so I'm not sure how they plan to do it. I hope that that's the road that they plan to take.
Yeah, and they, as you put that, the jail cases, as we call them, are the most significant. And it's not only caused a problem for them, many of whom are not getting their trials, but access of lawyers to the clients in the jail is always a problem. And it's even a much greater problem right now. So you don't even have really a fair opportunity to consult your client, especially under these circumstances. We're finding that. Are you finding that?
Oh, I mean, look, they've been handling it as well as they can. In terms of obviously the federal courts, they have been making at least phone calls available. They've allowed for in-person visits. But again, it's incredibly, incredibly difficult. It's difficult as is even to get the discovery from the prosecutor, because half the prosecutors aren't even in the office. Some of them are working out of state. And so you need to get the discovery, and then you need to be able to provide it to your client. Imagine your client being incarcerated during that period of time. It's so incredibly difficult to get anything done efficiently.
Well, just as a FYI, Jersey just had, I think, about 1,000 inmates released early from their max states. They had a number of criteria, and a number of people have been released because they've got this COVID care credits. And it's been really extraordinary about what everyone is trying to do to unburden the jail system and the criminal justice system. Julie, we got to switch gears a little bit here to Jacob Blake. You may remember him out of Kenosha, Wisconsin. This was the individual who did not listen to officer commands. Officers were called for a domestic violence incident. He was tased, I believe, at least once, maybe 2 times, and that did not work. He continued to go to the vehicle. There was an officer heard on tape shouting "knife," and Jacob Blake was shot. It is a controversial case. So there has been a resolution, however, to avoid a sexual assault trial that was supposed to start today and on Friday. The prosecutor agreed to drop criminal trespass and third-degree sexual assault charges for the defendant, admitting to 2 counts of disorderly conduct and 2 years probation. Julie, the interesting thing I found about this case is that the charges that led the police there on that particular case where he was shot with that particular victim, that is the mother of his children. And from what we are reading in articles, the charges deal with domestic violence of his children's mother that alleged over many years he was, quote unquote, terrorizing her, including 2012 stealing and crashing her car, 2012 stealing an Xbox from her home, 2016 assault, where she refused to give a password for her phone, and then the 2020 domestic violence incident that led to this shooting. Julie, to me, it was interesting. People will look at this and say, oh, they gave a guy a break on the sexual assault case. But this is what prosecutors do every single day. We'll drop a couple charges here. We'll plead him guilty. He got 2 years probation. But what I found interesting, Julie, is they didn't globally resolve the case, and they left that domestic violence case open. What were your thoughts about that? Because I was like, boy, that's peculiar.
Yeah, it's interesting. I noticed that as well. And what stood out, look, in the case in which he pled guilty to the violation, to the disorderly conduct, which I believe in that state are misdemeanors, in New York they're not. My understanding is that the complainant just would not cooperate with regards to that specific case. Now, simply not cooperating doesn't mean that a crime didn't happen. It means that the witness just doesn't want to go forward. And there can be many reasons why an individual doesn't want to go forward. But you're right. The other aspects of the case are not resolved. They're still open. I'm not sure why. I'm not sure if he's unwilling to plead to those or if they think that they have a stronger case in regards to those. But yes, he still has those pending charges as well.
Well, the interesting thing, he goes into that case, Julie, that hasn't been resolved with now a conviction, which always can increase the sentencing aspect should he be convicted of the domestic violence related incidents. Excellent. Let's listen to Ben Crump, who was the attorney for Jacob Blake, and some commentary that he had with regard to the police officer shooting him.
These 3 little boys are going to have psychological problems for the rest of their life. Can you imagine what his 8-year-old son, who was celebrating his birthday, is going to think about every time he has his birthday? The pain in his father. Can you imagine? This is real. This is real, America. This is real. This is what we have to endure every day. Being profiled by the people who are supposed to protect and serve us.
All right, Julie, I'm willing to play devil's advocate with this. And again, this is what lawyers do, all right? We're not saying it's not a political statement or what have you, but the officer's defense in this particular case, and I have gone through the weapons training course, and they indicate that you're losing control. Constructive authority is not working. They go to less than lethal force. That's not working. He's still not listening to officer commands. And while I understand the optic of being shot in the back is terrible, there's also children inside that vehicle, and the officers don't know whether there's going to be harm to those children. There supposedly is another cop yelling knife. And I'm just going to ask, this is what we do in law school, right? We do the hypothetical scenario. And in cop world, this is what they do as well. What happens if he grabs that knife and harms his children? So what kind of position? That is going to be the defense in this case. And they're going to maybe try to bring out all these other incidents of criminality, including the conviction that will probably be admissible when he takes the witness stand, which is another big thing, because you're allowed to use that to cross-examine the credibility as to whether the person is a law-abiding citizen. Thoughts on any of that?
So, look, I think it's okay to be, to have this discussion. I think it's important to have this discussion and be able to delineate the facts from different cases, and the facts, at least for me, in this case, are very different from some of the more troubling, incredibly troubling cases we've seen, for example, George Floyd. And so I think there's, in regards to what we see here, there does seem to be, at least, from watching the video, steps made to control the situation before shots are fired. Now, obviously, people have a lot of questions about why so many shots were fired, why he was shot the way he was, were there other means? And if the law should be changed, the law is less about the officer and more about whether or not there needs to be some change in how the police handle these cases. I'm not 100% sure that in another situation it wouldn't have been handled the same way, but I'm hesitant to compare this case to other much more egregious cases. At least that's how I view it at this point. There might be other evidence that comes out that changes my view, but so far that's how I see it.
Yeah, that's Julie, and a very fair point, and people tend to lump them all together. But I know that this is a controversial statement as well. But in a lot of cases, and I'm sorry to say, I'm not saying I agree with you. Many of the other cases are very, very difficult to deal with from a police procedural point of view, but listening to officer commands is an essential part of survival. I mean, I do it when I get pulled over, hands 10 and 2, lights go, on so that the officers can see my hands, the windows go down, because these cops are trained over and over again about the lethality or death they confront, mostly from motor vehicle related incidents. So that psychology and training is playing into the minds of these officers when they're going on these scenes, and when they're losing control of the scene, they don't know what's to happen. And I will tell you, in the facts training, they call it, I don't know what that acronym stands for, but when you have like simulated shootings, they have one specifically with regard to a person grabbing a knife, and one person grabs it and actually goes to put it in their pocket. That would be no danger to the police officer, and another person uses it to slit the throat of another person. And it's a split-second decision that needs to be made by the police officer. And I thought one of the greatest things that was ever done was one local sheriff's office years ago brought some activists forward, gave them the training, and basically those individuals, after they went through that training, realized what a difficult scenario it was for those police officers making split-second decisions. Does that mean there shouldn't be reform, better training? No. What do you think on Facebook Live with regard to this case of Jacob Blake? I'd love to know. We're going to take a quick break. We'll be right back. Welcome back to Law&Crime Report. I'm your host, Bob Bianchi. Okay, guys, we have a new case. It's a fascinating case. The defendant's name is Alfredo L., and that's just the letter L. Now, we don't think that's his full name. I'll explain that in a minute. This was with regard to the November 4, 2019 killing of 3 women and 6 children. Basically, these are Mormon, Mexican-American citizens that have dual citizenship. There were 3 cars of people, including a number of teenagers. Many of 8 other children actually escaped this horrific, thing. And Alfredo L. is accused of being part of organized criminal activity. And 2 vehicles were traveling together, and they were shot up. And a 3rd vehicle traveling about 10 miles away were shot up with these folks as well. So they have been trying to solve that case. Now, we just received information just late last week that Alfredo L. has been arrested by Mexican authorities for murder and being involved in organized criminal activity. But we have very, very little details. I will say there was one kind of clue I found in trying to research this case, and I could be making complete speculation here, that the family was from Mexico. Like I said, they had dual citizenship, and they're related to the LeBaron family. So I'm wondering whether or not the Alfredo L will ultimately stand for LeBaron, and that is just pure speculation. I was just doing my best to try to find out the facts, and the details have been very scant. Julie Rendelman, I also want to talk to you about a statement where the Mexican authorities indicated and used the word that Mexico says that he is a likely participant in the events that day. So I know we don't really have a lot of data and a lot of information to research the case, but it was obviously a horrific and traumatic experience that these folks went through. And now we're in the Mexico legal system, which, if I recall from other cases, will not extradite defendants to the United States unless there is an agreement that the death penalty won't be sought. Am I right on that?
I believe you're correct. I don't know offhand, but yeah, I was reading about this case last night. It's so horrifying. It's so horrifying to imagine the kids that remained alive, that watched what happened, and were either protected by other children when they were shot at, or managed to survive. It's just unbearable to see these poor children.
Yeah, really terrible case, but we'll have a lot more developments here at the Law&Crime Network. Julie, let's switch gears to Brandon Willie Martin, 27 years of age. He was found guilty of a triple homicide, and that involved the mother and the father and a ADT security person that was installing security equipment because the son was decompensating mentally. He was making threats. The defense says that he was suffering from drug abuse and psychotic episodes. Then he should be kept from the death penalty. They are pursuing the death penalty, however, after this conviction. And I will note that one of the things that a lot of people were concerned about with regard to the decision to go forward with the death penalty, once again, here we are about prosecutors have a lot of power, whether to bring a case for the death penalty or not, was that on September 15th, 2015, just 2 days before the incident, he was taken to a medical center for emergency mental health concerns. He was ordered to be held for 72 hours, but they were releasing him early. And the mother had actually complained and said, please don't do that. We believe that he's a danger to the family. And ultimately, all three were killed brutally with a baseball bat. I should note, he played in the minors with regard to minor league baseball. Julie, I hate to keep throwing it again, but here's clearly going to be a defense as a mitigating factor. And just to explain to our audience, if you will, what the difference between aggravating and mitigating factors are in a death penalty case, and whether or not you believe, and I know you do, that his mental health condition and being released early, prematurely, because they did not have enough room or space or resources for him, will be a major compelling factor that these jurors will look at to give life rather than death.
Look, we go back again to all the cases we talk about where someone's death penalty eligible, where they pursue it and where they don't. This is another case where I understand that 3 innocent individuals died, and they died in the most violent of ways, and there's no excuse for that. But there's also no excuse for a mental health facility releasing an individual who is clearly a danger to society, such that the mother knew this was a horror waiting to happen. And so I think that this is something that the jury is going to hear about. And one wonders if the jury is going to be, of course, angry with this defendant, but also angry with the system in its inability to handle mental health issues.
Julia, I'm going to go to that point because I think it's such a great public service message. When I was the county prosecutor, we had a lot more robust mental health systems, but was doing more with less. They went right to the heart of the mental health network. And what I found, unfortunately, was we had to gear our jails, our county jails, to actually be mental health facilities. Many times the corrections officers were like, we feel like we're healthcare workers as opposed to corrections officers. We had to hire more psychiatrists, make sure that they got medications when they left the jail. Many decompensate if they don't have medications. And I can tell 2 cases that we found the person not guilty by reason of insanity because they were released early without their meds, decompensated, went into psychotic episodes, and killed. And again, that shows you the power of the prosecutor to make a decision as to whether it's an NGI or whether or not you're going to proceed with the prosecution. And as you note, proceed with the ultimate penalty. Any thoughts on that?
Yeah, no, look, I did as a prosecutor myself, we had many cases with horrible acts of violence where we agreed to an NGI because we believed that the individual was fit the narrative in terms of mental health or mental disease or defect. These days in New York, I do find, as someone who practices here, is there has become more sensitivity on the part of the prosecutor. I will give them this credit in recognizing and delineating those cases, even some violent cases where mental health plays such a role that the prosecutor recognizes that one of the ways to resolve these cases is not necessarily to put someone in jail for 5 years, but to figure out if we can deal with the mental health issue and handle that we can keep someone in society and make them a functioning, happy, helpful individual in society. And I noticed certainly in New York City, Brooklyn, and the Bronx, that's something that seems to be moving more towards that direction.
And Julie, we had to tell our audience, because it's important, when you get found either guilty by NGI or there's a plea by the prosecutor in the defense to NGI, that doesn't mean the person just walks out of jail. There are people that are, in Jersey at least, and I'm sure it's relatively the same, until you're no longer a danger to yourself or others, who have spent more time in the mental health facility, lockdown facility, than they would have had they been convicted of the crime. Thoughts?
That's exactly. A lot of people get very concerned. There was one jury trial that we followed here where I believe the judge told them in advance, I don't want you to worry in a sense in terms of NGI because this is what's going to happen to him, because you don't want jurors worrying that if they do an NGI that they find someone not guilty by reason of insanity, that they're going to release him onto the streets. And many individuals that cases result that way end up in a facility longer than they would in a jail.
Right, and that has to be cleared by medical folks in the end, and the government would have an opportunity to combat that in court, and a judge ultimately makes that. We call that Kroll decisions here. Do you do the same in New York?
Yeah, so it has to be several doctors that are involved in the decision making, and the prosecutors involved, and then the defense also weighs in at some point. But yes, this is, and they're not evaluated every year. I believe that after one evaluation, if they're found to be dangerous, still it moves on. It's longer period of time.
Agree completely. Julie Rendelman, you're awesome as always. Cathy Russon, thank you so much for what you've done. Listen, I'll be back Thursday. Stick with us for our regularly scheduled program. You can find me at rbianchiesq. Have a great week.